That is case number 106986, State of Kansas v. Cooper.
Good morning. I'm Rick Kittle. I represent Mr. Cooper, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Mr. Cooper was found guilty at a jury trial of one count of level 4 aggravated battery. And unless the court has questions about the facts of the case, I would like to move to the issues raised in the brief, and I'd start with issue 2, which deals with the lesser included offense instruction. At the instructions conference in this case, at the outset of the instructions conference, the court just announced that it had consulted the PIC instructions, and under the law, it could not be, the lesser included offense instructions could not be given. And after the court made that statement, defense counsel also indicated that was his interpretation of the law. If you look at the PIC instruction in question, which is PIC 54.310, one of the comments after that PIC instruction reads, "A through and through bullet wound is great bodily harm as a matter of law and can only be severity level 4, intentional, or severity level 5, reckless aggravated battery. Therefore, severity level 7 and 8 aggravated batteries cannot be lesser included crimes." And the support for that principle of law in the comment cites to 2 cases of this court, State versus Valentine and State versus Bryce. But if you actually go and read State versus Bryce, which is a 2003 case, one of the quotes from Bryce indicates that, from this court says, quote, "We do disapprove of the statement in Valentine, Whitaker, and Moore that a through and through bullet wound is great bodily harm as a matter of law." So it appears that the court was relying upon that comment as an absolute. Anytime that there's a through and through bullet wound, it's great bodily harm as a matter of law. No lesser included offenses can be given. Bryce is given a support for that statement, but Bryce actually apparently says almost exactly the opposite, that it's not necessarily great bodily harm as a matter of law.
And because the defense attorney made the same legal error, or what you allege to be a legal error, that we have to apply the clearly erroneous
I think that's true.
standard of review.
I think that's true. And, you know, I guess if somebody just read that comment, it wouldn't be surprising what the court concluded and what defense counsel concluded, because that, like I said, that's stated as an absolute. But that's certainly not what the law is. And if you look at the law since the time of Bryce, there's a case of this court, State versus Williams from 2012, which says that a bullet that goes through the body without hitting a vital organ may or may not cause great bodily harm. So I think Bryce and Williams reflect an understanding that, to the greatest extent possible, the question of whether a wound is great bodily harm or something less should be left to the fact finder if possible. So the question to be asked in these situations, according to the case law, is, could a reasonable jury have found the defendant guilty of the lesser offense of level 7 aggravated battery?
That's not our standard for clearly erroneous. It's are we firmly convinced that a jury would have convicted?
That's true. And, you know, I guess perhaps I'm thinking another way of saying that, and I'm not sure if this is actually quite on point, but another way of saying that would be, if the defendant had been found guilty of the lesser included offense, would the evidence have supported?
That would be a good analysis if he had requested it.
Right.
But he didn't.
He did
And
not.
so the hurdle, the bar is set much higher.
The bar is higher.
Haven't we?
Pardon me?
We've set it very high.
That's true. It's a high standard to meet. But I think if you look at it in this case, and if you consider the evidence that was given on the nature of this wound, first of all, you have the victim stating that, and I think this is at page 3 of the yellow brief, the victim said that, this is a quote, "The bullet blew part of his toe off and a little chunk out of the ball of his foot." The,
Counsel, was there, the photograph that's in the record, was that given to the jury?
I believe it was, yeah.
So we don't really have,
Two photos.
two photos, so it's not compelling the visual laid out by the words describing when they got to see what the jury got to see.
Yes. And I suppose the jury could have made a decision on, or looked at that and gave it whatever evaluation it wanted to. The victim was treated at an emergency room. The emergency room physician did not testify, but an emergency room nurse did testify as to her observation of the wound, and she described it as, quote, a single gunshot wound to the right great toe with a graze wound to the top of his foot. And she could not recall if there was an exit wound. So the first point here, I guess, is it appears that the court, in relying upon the comment to the PIC instruction, must have concluded that this was a through and through gunshot wound. I'm not sure that the evidence ever supports that. If we assume that a through and through gunshot wound is a wound where the projectile at some point is completely contained within the victim's body at some point, I don't know that that's actually ever what happened here, and I don't think there's any evidence to conclusively support that's what happened.
Well, counsel, if we agree with your argument that the comment to the PIC instruction is legally erroneous, so that, in other words, this lesser included instruction would have been legally appropriate to give, and it was factually appropriate. If we concede or we agree with you on those, I'm getting back to Justice Johnson's question, what's the best evidence in the record that you can present to us to convince us that we should be firmly convinced that the jury would have convicted on the lesser? In other words, a simpler way to put the question is, why would the jury have found that this wound was moderate rather than great?
I suppose if you look at it this way, if you consider the range of wounds that might be caused by a single gunshot wound, at one end of the spectrum you have obviously death, or paralysis, or severe and permanent disabilities. At the other end of the spectrum you have possibly the graze wound that was mentioned by the emergency room nurse that testified. If you consider that scale, I would argue that if you look at this objectively, the wound that occurred here has to fall much lower on that scale, and the lower it is on the scale, the greater the need for the lesser included offense instruction.
But counsel, that doesn't answer my question, because I premised the question by saying, well, let's concede that the instruction would have been factually appropriate. In other words, the jury, from the evidence, might have found that it was a moderate wound. But I'm asking you for your best argument to hit you over the higher hurdle of saying, why should we be firmly convinced that that's what the jury would have found? And because that's what you have to get over, right, to make a claim of clear error.
Well, suppose in this case the jury had been given a choice, given the choice of the greater offense or the lesser offense. In this case, we don't have any evidence that this bullet struck a vital organ. We don't have any evidence that obviously it didn't strike the defendant or the victim in the head or the torso. There was no evidence that this was severely debilitating. There was evidence regarding the pain suffered by the victim. There was evidence, but there was no evidence that this was in any way life-threatening. Given all of those facts, I think you could be firmly convinced that if the jury had been given an opportunity to assess this and say, well, is this great bodily harm? And do the same type of measurement I'm doing, saying, well, is this great bodily harm where, a bullet wound could have caused death? Or is this something less, where it clearly was just an injury to his foot, which...
So let me just rephrase the question. I'm sorry to pick on this, but what's the best evidence in the record that the wound is moderate? Is it the photograph? Is it the nurse's testimony? Is it the victim's testimony? What, in your view, is the best evidence in the record for that proposition?
Personally, I think the best evidence is the testimony of the nurse. The nurse indicates that there is a wound there, that there's a wound to the toe, but she also refers to a graze wound. And that's something that typically, when you're looking at the scope of injuries, you're going to think of something as much less severe than what possibly could have occurred when you typically think of a gunshot wound suffered by a victim. I have a couple minutes here. If I may, I'd like to just kind of address the other issue regarding the question asked by the jury during deliberation. And I filed a 609 letter some time ago with this court, asking the court to look at several cases, some of which are Kansas cases. They're pretty old, and then there's some other more recent cases from other jurisdictions. I guess one of the things I'm asking this court to do out of this case is to make an affirmative statement that under Kansas constitutional law, an accused has constitutional rights associated with the presence of the judge during the course of the trial. In the cases that I've cited in the 609 letter, these are cases where, for some reason, the judge just left in the middle of the trial, left the courtroom, put a clerk in charge, got the parties to agree that if the jury returns a verdict while I'm gone, we're going to have a member of the local bar accept the verdict because I can't be here. Those types of things.
You would agree that those cases you cited in your 609 letter are not factually comparable to the facts in this case. As you just recited, those were all cases where the judge literally was gone, abdicated his role.
I agree that this is not a case where the judge just left, like these cases. But the judge doesn't have to leave the courtroom in order to be absent at a critical stage of the trial. And the argument I've made on these types of cases all along is that when a note is used to respond to a jury's question, the controlling law says any communication between court and jury is a critical stage of the trial, and when a written note is used and delivered to the jury, that communication doesn't take place until the jury reads the note. And if that happens in the jury room, it happens at a place where the judge is not present, defendant is not present, public is not present, and so forth. So in that same context, in this case, a critical stage of the trial occurred in the absence of the trial judge, because when the communication took place, the judge wasn't there.
Let me and again, this is how I understand this communication to take place. There was a question from the jury, and as the judge notified counsel, the question was read to counsel with his client present and state present. An answer was formulated, agreed to by all the parties present, and then that communication, that answer, was then transferred to the jury or the jury foreman in the jury deliberations room. Is that how that occurred?
What the record actually indicates in this case is the lead up to that. The question is asked, parties and court get together, court rules upon what the proper response is, and then the next thing that you see in the trial record is just the jury resumes deliberation. There's no indication in the record that the jury is ever brought into open court to have the response read to it. There's no indication in the record as to what happened. In that situation, according to this court's case in Herbal, I think we have to assume that the defendant was not present because the record doesn't say that he was present for that purpose. And therefore, I'm believing that what happened here is what typically happens in these situations. A written note was used, delivered to the jury in the jury room. And the problem with that is that there is nobody there, in the context of an absent judge, there's nobody there to preside. There's nobody there to control the situation. And as I've said before,
Control what? The handing of the... There's no one to control the oral communication. There's no one to control the handing of the answer to the...
Let me address that first of all by saying this court has repeatedly said when this situation happens, the jury needs to be brought into open court to have the response given to it in the presence of the defendant. So if a note is used, that's clearly a violation of what this court has said needs to happen.
Statutorily.
this case, this court's interpretation of the statutory
And
law.
why does it make any difference if it's constitutionally required rather than statutorily required if we apply harmless error to constitutional errors also? The only way you win is if you say it's constitutional and structural error.
And that's what I am saying. I'm saying,
But
typical.
so your argument isn't why it fits within the Constitution, it's why it's structural.
Well, yes, but I guess when I stated I would like this court to make an affirmative statement that the defendant has constitutional rights associated with the presence of the judge, I'm asking that because I don't really find any definitive statement in Kansas law that actually says that. We have these old cases that I included in the 609 letter, which kind of give some sort of indication that the defendant has good cause to complain if that happens, but that's not really an affirmative statement of the constitutional rights associated there.
Can I ask a broader kind of conceptual question? Is structural error inevitably constitutional error? Is it necessarily a subset? Is there some statutory error that can be structural as well? Does anything come immediately to your mind? I know that's far afield from this.
I'm not thinking of anything off the top of my
Okay.
head.
Thanks.
But I am saying this is structural error, and Justice, as you indicated, the facts of these the cases in the 609 letter are, you could say they're much more egregious than what we have here, because the judge in this case didn't simply say, well, I've got to be somewhere else and leave. But the effect is the same. The effect is to have a critical stage of the trial outside the presence of the judge.
The problem wasn't where the judge was, it's where the jury was. Arguably, the judge was still sitting in the courtroom. So the real problem was that the jury wasn't brought to the judge, not that the judge didn't go to them.
That's true. And as I indicated, that's a violation of what this court has previously stated needs to be done. And Justice Rosen, trying to get back to the question you asked, this could be something very simple. You know, a note could be delivered to a jury in the jury room, and the jurors may say, one of the jurors may say, I can't read this. I can't read the handwriting. And so it's possible that a bailiff may say, well, here's what it said. I was in the courtroom. I heard all this. Here's what the note says. So at that point, the law is being given to the jury by someone other than the court. Or it's the bailiff or whoever, their interpretation of what was said in that note. And in these situations, there's no record being made of what happens, which leaves everyone in the dark. I think that's probably one of the reasons why this court has required that the jury be brought into open court so that there can be a record of the proceedings made. But when a note is used, we don't have that.
Well, that's not the reason why we've said that. The reason is because the defendant has a right to be present, right?
That's true, but one of the residual effects of having that happen is if they're in courtroom, then a record would be made of what's going on.
But your argument is that your client has a constitutional right to have the judge present, which doesn't naturally flow from what this court has said with respect to your client's right to be present himself.
I agree. I'm talking about more than one right. I'm saying, yes, there's a violation of the right of the defendant
But citing
to be
this
present.
citing this court's precedent with respect to your client's right to be present isn't determinative of your secondary argument.
No. And typically, that right of the defendant to be present has been viewed with harmless error. What I'm saying is, if you look at the cases, it's a much more serious thing when the judge is not present for trial, and it's so serious, in fact, that in some instances that's been viewed as structural error. And that's why I think in this case it should also be viewed as structural error. It's one thing to have this take place outside the presence of the defendant, but it's an entirely different thing to have it happen outside the presence of the trial judge. And that's one of the reasons, at the very least, I'm asking this court to make an affirmative statement that the defendant does have constitutional rights associated with the presence of the judge at the trial. Because I don't think that's ever been said in Kansas law based upon Kansas constitutional provision. And I see that I'm long out of time, so I guess I would entertain any other questions the court might have.
Any more questions? Thank you, counsel.
Good morning. May it please the court. Jennifer Tatum on behalf of the state.
Ms. Tatum, could we pick up where your opposing counsel left off, just at least briefly, and then I don't presume that that's where you wanted to spend all of your time, but I just want to try to hit a point real quick before I forget. Opposing counsel ended with the idea that he wants a statement from this court that the defendant has a right to have a judge present at every critical stage of the trial, that he just wants an affirmative statement to that effect. Now, he wants more than that. He also wants us to say that the delivery of an answer to a jury question is a critical stage, and that the judge must be present for that, and that there was a violation here, and that it's structural. He wants all those things too, but let's concentrate on the first part. Is there any harm to the state in that affirmative statement? There's no harm in that. It's kind of self-evident, isn't it? That if you have a right to an impartial judge, you have a right to a judge who's capable of acting, which means the judge should be present? Or is there some harm I'm feeling to proceed?
Well, I don't think there's any harm in saying the judge should be present when the answer is given. I know that this isn't the way it's always been done. Obviously, through the course of the years, many jurisdictions, not only Wyandotte County, the judge was giving written answers to a jury.
Mm-hmm.
And just recently, that's changed, even since this case was argued, actually, because Wells came out after the jury trial in this particular case. But I believe this court has made the affirmative statement already that constitutionally, the defendant has the right to be present at all critical stages.
The defendant, but the judge is what he's asking for.
And I think that it follows if the defendant has the right to be present at that critical stage, the judge should also be there, and that's going to cause no harm to the state. If everyone's in the courtroom and the judge is delivering that answer to the jury himself.
Okay.
The
So
defendant
that
has to be
building
there.
block, you don't have any, that building block of this argument, you don't have any heartburn with?
I don't. I hate to speak on behalf of the whole state, but I can't see any harm in that.
Okay.
Of course, I disagree that it's structural error in this case, or that those sorts of that sort of review should apply to this case. I don't see any harm in that. And I do think this court has spoken to that in the Verser case in 2013, in the King case, all of those cases, which have happened subsequent to this case. But in this particular case, I think structural error should be, well, you asked a question earlier, Justice Breyer, about structural error. Does it always follow that any constitutional error is structural?
Actually, it was the reverse.
Okay.
Is every structural error constitutional? I was trying to determine whether structural is necessarily a subset of constitutional, or whether statutory or other error can also be structural.
My answer to that is I don't think it is. I guess my answer would be no, whether it's statutory or constitutional. Reason being, I think structural error over the years has been reserved for fundamental failures in a proceeding. In this particular case, what we have is we went through a jury trial. The jurors had 3 questions. They were pretty simple questions. The first one was about reasonable doubt. Can you define it further, or can you give us synonyms for it? All the parties agreed in the presence of the defendant that no, the judge shouldn't do that. So he simply said no. The second question was whether or not the court could further define something in the eyewitness identification instruction, what a term meant, what the term length of time meant, or opportunity to observe. Again, the parties all agreed to that answer. It was very simple, just the length of time the witness had. And then the third question, I believe, it was about the alternate juror. Could she come in and give her opinion on the facts? And the judge simply said no. So that's what happened in this case. That's not a structural error, I don't think. I mean, this is not a fundamental failure of the proceedings. All the parties agreed on these responses. They were all appropriate under the law. They're communicated to the jury, and there's no reason to believe there's any problem in the jurors' understanding of them, or that the bailiff miscommunicated them, and that was it. The defendant.
What was the full response on the second question again?
I believe in the second question they were asking about the eyewitness instruction. It said something about the opportunity the witness had to observe,
Right.
and they wanted to have a further explanation of that. I think all the parties agreed that it was pretty obvious that it meant the length of time, something along those lines. And I'm paraphrasing because it's been a while.
Okay. I remember now. Thank you.
Sorry. thought Justice Rose was going to speak. But at any rate, I don't think that that would constitute a fundamental failure of these proceedings, particularly not when this defendant was on board with the responses that were given and they were appropriate under the law.
I think your opposing counsel's worry on the judge's presence is more directed at what might have happened when those answers were received. He gave the example of the handwriting being illegible to the juror and then the bailiff having to have some input other than handing the note to the presiding juror. More on that than on the content.
I think that we can always worry about the things that happen in the jury room and speculate on all types of things. Did each of them hear the evidence the same way? Do all of them understand all the words we use in the courtroom? But that's really not the standard that we're reviewing here. I think what it comes down to is, in this particular case, is whether or not I'm sorry, I lost my train of thought there. I think the standard is it structural error or not? And I don't think it is. I think it's harmless error. This is the way the court has routinely reviewed these cases. And in this particular case, we had 3 eyewitnesses that identified this defendant as the shooter. We had evidence that from a nurse or a medical professional that he suffered a gunshot wound. He talked about the lasting effect of that, that it bled a lot. He still had pain 2 years later. We had all of those things in this trial, relatively overwhelming evidence. So I guess what you have to ask yourself is, if the judge had been there when these responses have been given to the jury, would that have changed anything? I submit to you that there's no reason to believe that's the case. I'd like to move on now to the second issue, if that's all right. But if anyone else has any further questions about the first issue, I'm willing to entertain those. The second issue on the lesser included offense instruction, the clear error standard. I'm not conceding that factually it should have been given or not, but I think for purposes of the argument today, both Justice Johnson and Justice Stagel have both said let's assume that it should have been given. And so I'll do that for purposes of my oral argument. But the standard is high. It's whether or not you're firmly convinced that if it had been given, a jury would have decided in a different way. I don't think that the defendant can reach that hurdle today. I read the
Counsel,
court.
let me follow up on that. If, as we heard from defense counsel, some of the best evidence in the record to support the conclusion that the wound was moderate rather than great is the nurse's testimony, what's the converse of that? What do you put on the other side of the scale? From the state's perspective, what's the countervailing evidence that the wound was great rather than moderate?
I think the strongest evidence it was great comes from the victim himself when he described the bleeding, the pain he suffered at the time, the pain he still sometimes suffers 2 years later. I think the pictures tell the story too. I don't have them here today to show you. But I also think that the nurse's testimony supported that this was great bodily harm. She said that the victim was in a lot of pain. I'm not sure where we're getting the standard that great bodily harm means it struck a vital organ or it could have resulted in death. I mean, the definition under the law is basically it's more than slight, trivial, or minor. And I think both the testimony of the victim and the nurse in this case established that. And so I don't believe you can be firmly convinced if that lesser included instruction was given, the verdict would have been different.
And just so we're clear, the instruction we're talking about, or the crime, the lesser crime we're talking about would have been aggravated battery by causing bodily harm with a deadly weapon.
Yes, I believe that's what he submitted, the level 7 aggravated battery.
Any further presentation?
No, unless there's any further questions.
I have one follow-up question, and I appreciate that you took my earlier questions to mean assume it should have been given, but I do want to take you back. You said you weren't waiving the state's position on the PIC instruction in the comment. I want to take you back to the Valentine case and the PIC instruction itself. Is there an argument, or are you advancing an argument to keep that standard that's recited in the comment that comes from Valentine, where this court essentially said we can't imagine a situation where a through and through wound is not great bodily harm? mean, should that be the standard? I guess what I'm asking is the comment correct? Is it legally correct?
Well, I think this court disapproved of the comment in the Bryce case, but if you're asking my opinion, I think through the bullet wound probably should always be great bodily harm by definition, because I don't think any gunshot wound is minor, slight, or trivial. But however, I respect this court's ruling in Bryce, and if that's the ruling in Bryce, I guess that's not consistent with the comments in the Pick instruction.
Well, the harm in doing that is taking that element of the crime away from the jury. When the judges start saying what's great bodily harm, then we've taken that away from the jury, and it is an element of the crime that, under our system, the jury is supposed to make that determination. Don't you agree? I mean, why isn't, if we say as a matter of law, particular injuries take that element out of play, why aren't we invading the province of the jury?
Well, I'm not sure what led to the original case law that established that precedent. I'm not familiar with why it was the way it was, but what I can tell you is I know that jurors do routinely decide the difference between great bodily harm and bodily harm in all types of cases that aren't related to gunshot wounds. I know they're capable of doing that. I don't know if that helps answer your question.
Any more questions? Thank you, counsel. You reserve 3 minutes for a vote.
I will concede that the questions asked in this case by the jury were not particularly complex or difficult to answer. But the simplicity or complexity of the questions here isn't the issue. The issue is the procedure used in communicating the answers to those questions to the jury.
And the answers to the questions were tantamount to jury instruction. Wouldn't you agree?
Yes.
That when you clear it just, and so basically you're saying that a defendant has a constitutional right to have the judge advise the jury of the law that's applicable to the case.
I think that's part of it, because that involves the presence of the judge at a critical stage of the trial.
I need to, I'm just trying to clarify in my own mind what exactly you were advocating. So if you bear with me while I
Sure.
try to clarify that for my own help. We've talked about, and the way you've advocated this morning has been in the context of talking about your client's right to have the judge present. But that's not, well, help me understand. As I read your brief, at least, the constitutional right that you're alleging in your brief is a right to an impartial judge, which is not the same thing, it seems to me, as the right to have the judge present. Am I thinking about that correctly, or?
Well, I believe that the right to an impartial judge implies that there is a judge there.
So there are cases, and these would be the cases in your 609 letter, where courts have found that when a judge abdicates his role, then that is a violation, not of a defendant's right to have the judge present, but that's a violation of a defendant's right to an impartial judge, correct?
Well, I
And
don't
that's
know
how
that-
you get there, right? That's how you get to the violation of a constitutional right. It's not just because the
Well-
judge wasn't there, it's because the facts that are on the ground demonstrate that the judge wasn't impartial.
Well, it could go down that path.
Well, that's how those cases, that's the analytical path that those cases describe.
I'm not disagreeing with that. That's why I'm also asking for this court to make some sort of an affirmative statement. There is a Kansas constitutional right associated.
But what is that right? Is it a right to an impartial judge, or is it a right to have the judge present?
Well, I think there's already in existence a constitutional right, whether it's federal or a federal applied to the state, to an impartial judge. I think there also should be a right just to the presence of the judge. Because the presence of the judge is necessary. If the judge is not present during the course of the trial, that undermines the integrity of the proceeding.
Is there any case that you can cite that says what you just said?
Well, those are the more recent cases from other jurisdictions that have said that this undermines the integrity of the proceeding.
But as I read those cases are premised on the defendant's right to an impartial judge.
Well, that may be. Either way, I think there's a violation of the defendant's constitutional rights.
I just am trying to understand which right you're asserting.
I'm asserting both. I recognize the current existence of the right to an impartial judge.
Right.
I'm saying, looking at all these Kansas, well, not all of them, there's just a few Kansas cases that I've included in the 609 letter. They don't really come out and say the defendant has a constitutional right to have the judge present at his trial.
That's right.
Partial or impartial.
What they say is that a judge's abdication might be evidence that the judge was not impartial.
Well, what I'm getting from those is just some more of a weaker statement saying, well, if that happens, then the defendant has a right to complain. But what does that mean? Does that mean that there's a constitutional right associated with him, with the presence of the judge? I think there should be, and I think there should be a statement. I'm asking that this court make a statement, an affirmative statement, that under Kansas constitutional law, the defendant has a right to have the judge present.
Which provision of the Kansas Constitution?
On the trial right provision under the Kansas Bill of Rights.
Would you, can we get to the injury question? Sure. Would you, is there a point at which a level 7 aggravated battery instruction would not be given in your mind if a level 4 is charged? In other words, if there's great bodily injury, would it always result in a lesser included instruction for just bodily harm?
I filed 2 609 letters in this case. One of them dealt with a much more recent case of that talked about jury nullification case of this court. And even though a jury can't be instructed on jury nullification, the power exists for a jury to, even if all of the elements of the charged crime are proved, the jury can say, no, we're not going to convict him of that. I'm thinking that in that situation, if that's the right of the jury to completely nullify, then the jury should be instructed on all lesser included offenses in every situation. Because there's a possibility that even if the evidence is supporting the greater offense, they could still find the defendant greater of the lesser, or guilty of the lesser.
Let's say the injury resulted in his hand being severed. Would a lesser included of just bodily harm be warranted?
If you look at the Williams decision, which says a through and through gunshot wound that does not strike vital organs may or may not constitute great bodily harm, I think under that rule of law, a lesser included offense instruction would be justified, even in those circumstances.
But the lesser included offenses emanate statutorily from the provision that speaks to the evidence that would justify a conviction of the lesser. Correct? And so I think the fundamental difference, I think, is whether you focus on the quantity and quality of the evidence in relation to the charged crime, or if you look at the evidence that supports the lesser, is the hang-up, the two views. If there's so overwhelming evidence of the charged crime that we don't need to give the lesser, or if there's evidence that would, if you just look at the lesser, it's a different analysis.
It is a different analysis, but I think overarching this all is the thing you mentioned, Justice, that whenever a court says as a matter of law, this is great bodily harm, that removes from the jury its accepted function of finding the facts in the case.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. Now